I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my orally argumentative co-host, Brett.
Hi, Alice. It's a pleasure, as always, to be here with you, up from my sick bed to join you.
I'm so glad that I'm able to talk to you today, but you have been so sick. I know we've had to reschedule this one many times over. And guys, really, he should be in bed now, but he really, really wanted to record for all of you. So thanks, Brett, for being here. But I don't think I was trying to go for a pun. I literally was just hitting it on its head. We're talking about oral arguments today, specifically we all know that in Delphi, the Indiana Supreme Court has set oral argument for the former defense counsel's motion, basically to mandamus the district court judge to put them back on the case. They were removed previously for gross negligence, and they had submitted papers, meaning they submitted a brief. The state responded, as well as the judge responded, and now there's oral argument. What does this mean? What are the standards to have an oral argument? What's going to happen at oral argument? Does this mean that the former defense counsel are definitely going to be reinstated, or they're definitely not going to be reinstated? Hopefully today we can answer all of those questions and show you how kind of the procedure of oral arguments work to demystify the process. And we don't have a crystal ball, but we'll give you kind of some thoughts on what we think may happen on January 18th when the Indiana Supreme Court has set oral argument in this case.
Yeah, and this is one of those aspects of the law that a lot of people, if you don't follow it closely, you may not even know what oral argument is. You may not even know that they exist. It's one of those things that I would say, I don't know what the percentage is, but the vast majority of lawyers will never have an oral argument. You, loyal listeners, are very fortunate because I don't know about Alice. Alice, have you had an oral argument before?
A lot. Yeah. Well,
oh, there you go. Well,
this is very interesting because oral argument can happen at every level of court, district court, appellate court, and Supreme Courts. Typically, you see the term oral argument where you're talking about an appellate argument. So you guys are very lucky. Brett was getting there, but let me just toot his own horn for him. He is an appellate lawyer. This is his bread and butter. Appellate oral arguments and appellate briefs is what Brett does day in and day out, and he is really good at it. I don't think that's a surprise to any of you.
Yeah, and I've had the opportunity to do a good number of oral arguments in front of federal courts and state courts. And Alice and I both clerked for a federal appellate court judge, so we saw a lot of them. We've prepared people for them. We know a lot about them. So this is actually an area where we can lend a little bit of expertise. And the thing is, when most of you think about court cases, you really think about either the trial court or maybe the United States Supreme Court. And there's nothing really in between. And in trial court, you think about a trial. You think about having witnesses on the stand and asking them questions and arguing to a jury and all that sort of thing. And then you have sort of this general idea of what the Supreme Court does. They're the final court, but maybe you don't even know how they get there. So oral arguments kind of flip things. A lot of lawyers hate them because rather than you asking the questions of a witness, the judges are asking questions of you. And in an appellate oral argument, the way it works is you'll have a panel of judges. You know, a lot of times in federal court, it'll be a 3-judge panel. I'm looking up right now how many judges are on the Indiana Supreme Court. But however many judges are on the Indiana Supreme Court, that will be the panel of people who will consider that.
Basically, procedurally, oral argument can happen if the parties ask for oral argument. So usually in a brief, you'll see either at the beginning or the end, it's usually at the beginning where it's like parties request or the petitioner requests oral argument. That doesn't mean you're guaranteed to have oral argument, but you're signaling to the court, I want to engage with you on this. This is a meatier issue than you can then the papers alone can address. And so I request oral argument. Sometimes both sides will request oral argument. Sometimes one side will and the other one will say, this is simple, no big deal. The law is clear. You can decide it on the papers without oral argument. Or the court can sua sponte, meaning on their own motion, decide to grant oral argument in a case. And those are really interesting cases if the court decides to set oral argument, because you can imagine the Indiana Supreme Court, like all other Supreme Courts in the country and the federal one, have a lot of cases before them, and they can't possibly hear oral argument in every single motion before them because they just wouldn't have enough hours in a day. So they do have to be judicious in when they grant oral argument. And typically, when you do set aside time for oral argument, it signals at the very least that this is an important enough issue. And important can mean lots of things. It could mean the law is unclear, or it could just mean there's a lot of attention on it, or a lot is at stake, even if the answer is clear, that they want to grant the attorneys the time to kind of hash out their arguments in court and to be able to interact with the judges. Because in an oral argument, you don't just stand up at the podium and talk in a soliloquy. You could, but typically the form an oral argument takes is to have engaging questions from the justices so that they can ask whatever questions on their mind and see if you'll concede certain parts or make you answer hypothetical questions to push your theory as far as possible. Because remember, especially when it comes to the Supreme Court of a state, their order, their opinion is going to have binding effect across all of that state's courts, the appellate courts and the trial courts. And the effect of that one opinion is going to be much more far-reaching than your case alone. In other words, the opinion in this oral argument will have a more far-reaching effect than just in the Delphi case.
And I think this is a really important point that Alice is making, because it's easy for us to get lost in sort of the minutia of the case we care about. So we all care about Delphi. So people always try and read the tea leaves. Okay, so they're having oral argument. Well, does that mean the defense attorneys are more likely to win? And I will say, typically, if you lost in the lower court, you want oral argument because it's just another sign that maybe someone's actually taking your argument seriously. Typically, when I write a brief, I usually say, in fact, I've never not said that the case is not worthy of oral argument. I have thought one time I considered saying, you should go ahead and take this on oral argument, but I didn't do that. And the other side, not always, but typically says, oh, this is so complicated, you definitely need to do oral argument. I always feel like when the side that loses says, you don't need to do oral argument on this, that's a signal to the court that what we're going to say isn't really that powerful, so just kind of ignore us. But anyway, so typically, it's a good thing. It's much better, for instance, than just being rejected out of hand. Like, you would rather have oral argument. But the thing to remember, this is a Supreme Court. So as we've said, we talked about this when we talked about the Adnan Syed case. Once a case is in the Supreme Court, it really is barely about the litigant. I mean, it is to a certain extent. Obviously, it is their claim that is driving the issue. You have to have a claim in our country. We don't issue advisory opinions, so you have to have litigants. You have to have some sort of argument. But at that point, the court really is concerned about what message are we going to send for the future. And they know that anything they do is going to influence the lower courts. So, for instance, if they had just denied Richard Allen's claim out of hand, that is a case that people would have pointed to for all time whenever attorneys were removed. And so it's not surprising to me that they would want to hear more about it. The other thing to think about in this case, this is an unusual case because it's mandamus. If this were a direct appeal, I think you would have a better argument that this is like a good sign for Richard Allen. In mandamus, you're only supposed to win if you have a clear right that's clearly been violated and that you are obviously entitled to. If he had those things, I think there's a good argument you wouldn't need oral argument. The court, it would just be obvious to them. He filed 2 mandamus petitions. The first one was denied as moot because the judge had basically done all the things they asked for. And I think if it were just obvious, I think it was obvious to everyone that the first mandamus should be granted. And if the judge hadn't done it, I think the Supreme Court would have just granted it because it was obvious that stuff under the rules should all be public. So the fact that they're going to oral argument, I think one of the things the state's going to argue, and we're going to get into what we expect the arguments to be, is, hey, if this were so obvious, we wouldn't even be here. You know, if this were clearly a mandamus-worthy issue, there would be no need for us to have this argument. It should be clear, almost to the point of not being arguable if you're going to grant. So that's sort of that. As to how this is going to go, there's 60 minutes for each side, just to give you a little bit more on the mechanics of this. Yeah, so there are 5 justices. There are 60 minutes on each side. These can go 15. I've done 15. I've done 30. I've never done 60. That's a little long, but in this case, you've got both the judge and the state are probably going to want to argue. You've got Richard Allen's attorneys that are going to want to argue, and the amicus, or the amici, who are the state federal defenders, public defenders who filed an amicus brief, they're probably also going to want to argue. So what's going to end up happening is that time is going to be divided up. And Richard Allen, as the movant, will be the first arguer. He and his people will argue first. They will pick a amount of time out of that 60 minutes, maybe 40 minutes. They'll divide it up between them however they want to. They will make their argument. They will get up. They will start to argue. Like Alice said, the judges will start asking them questions. It'll go back and forth until the time runs out. Then the other side will argue for 60 minutes. They'll use their whole time. Then Richard Allen, as the movant, will have an opportunity for rebuttal and will use whatever time he reserved to sort of attempt to push back on any points that were made by the state. And the other thing I'll say, just one other thing about grants. It's different in every jurisdiction. I'm not entirely sure how it works in Indiana. In the federal court, for like a federal appellate court, one judge can send it to oral argument. So if one judge thinks there's an interesting issue, they can say, let's send this to oral argument, and it'll go. In the United States Supreme Court, there are 9 justices. If 4 of them think it's something that's worthy of oral argument, it gets sent to oral argument. So probably with a 5-justice court, it wouldn't surprise me if it was 2 or 3 justices. If they want to have oral argument, they can. So it doesn't even necessarily mean that a majority of the court thinks it's worthy of oral argument. Just there are judges who want to hear it.
That's a really good point, right? Usually in these instances, every state is different. They can set their own rules, but usually you don't need a majority of the justices who will hear the case want to hear oral argument. And you can imagine why, right? That's a kind of a higher bar. And so you have something less than what you need to win in order to hear it. And so that's why you can't really read too much into whether the court thinks that Richard Allen's attorneys should get their mandamus here, because more likely than not, it's going to be something less than the majority that they would need to win in order to send it to oral argument. And a really interesting thing about the format that Brett just said here, across, all oral arguments, that's typically what it is. The movant goes first, makes sense. It's on their papers. They're asking the court to do something, so they have the burden to present their argument to the court, and then they usually reserve some time for rebuttal. So at the United States Supreme Court, for example, when you stand at the podium, there's like the 3 light system, right? The light is green when you have your time to talk. And then usually there's some sort of warning light around yellow, whether it's 5 minutes, 3 minutes, every court's different, but they'll tell you very clearly when you have, X number of minutes left of whatever time you have, it'll turn yellow, and then it turns red when you are out of time. And if you're the movant, you've usually reserved some amount of time so that you have time to rebut whatever the other side says. And so as it's being 39, let's say he wants 40 minutes, reserve 20 minutes for rebuttal. At 39 minutes, 59 seconds, and then all of a sudden it turns to red. So you're supposed to be able to stop talking at the red. Every court is different. It used to be at the Supreme Court where you stopped mid-sentence, even if you were in the middle of saying, and it turned red. And what you would do is you pause and say, Your Honor, I see that my time has expired. May I finish my sentence? Or may I wrap up, in under 30 seconds? And typically, out of courtesy, the court will let you do so, but it is not a time to run out your time. And so time constraints are more restricted to at the appellate courts than the lower courts. And an interesting thing to note here is the arguments should have been in the papers, right, in your briefs. So what are you arguing about if you've written out your arguments on the papers? Well, first of all, you do have to preview all of your arguments in the brief, but there's typically word count limits or page limits. So you can't, go ad nauseum on all the arguments, but you want to touch on your main arguments and develop them. But what happens at oral argument is you want to be able to demonstrate to the judge the arguments you've already made, but even deeper, and why you absolutely win. Now you have the benefit, by the way, of reading the other side's briefs. Whether you're the movement, you've now read the response. If you're the respondent, then you've read the reply brief. And you're able to kind of craft those particular examples or hypotheticals to highlight for the justices why your legal argument should win overall. And especially at the Supreme Court, it's your chance to engage with each of the justices because they may have pet issues that they're worried about. This happens at the Supreme Court a lot. Because the justices write over decades, you begin to understand their jurisprudence and what they're worried about or concerned about, where the law will go in certain areas. And you want to be able to speak to each of the justices in terms of what they may be worried about if they were to rule in your favor for all the other cases that would be affected by your case.
Yeah, and I want to clarify one thing. I said 60 minutes on both sides. Someone corrected me in the chat, and I just looked at the order. It's actually, I've never seen it written like this, but it's 60 minutes total divided equally among the parties, of which I guess there are three because you have Richard Allen, the state, and the judge.
So 20-20-20.
So I guess it's 20-20-20, and I guess it'll go however long Richard Allen wants to go, which isn't really fair to Richard Allen to have basically be opposed by two people who get equal time.
That's really interesting.
I don't know.
Typically
or maybe it's going to be 30-30, and then those two have to divide. I don't know. It'll be 60 minutes total. That's what we know. So we'll see how we'll watch it. It's on January 18th, I think. We'll watch it then. Right. We'll figure it out. But it's going to be 60 minutes total. But I just want to piggyback on what Alice was saying, because it is sort of always a question. A lot of times you'll get the order that says you're going to have oral argument, and you'll be like, I have no idea why they want to have oral argument. Like I can't even imagine what issue they want to discuss. It was all fully briefed. Both sides are pretty good. Doesn't seem like it's complicated. And that's the worst, because then you're like trying to figure out, what are we going to talk about when we get there? And sometimes... No, go ahead.
And Brett, on that very point, this is not a Perry Mason moment type of a situation. We've talked about Perry Mason moments in trial where, like, because it's a live circus, right? Like, you may have prepped your witness, you may have read the police reports, but you don't know what someone's actually going to say until they take the stand. That's not what happens at the appellate court. The appellate court is on the record. There's no witnesses. And so you have waived your arguments if you haven't briefed them in the papers before. So you get in a lot of trouble if you were to pull out some argument that you never talked about in a brief. You'll get probably grief from the other side, but you'll certainly get grief from the justices. And so there's not really the element of surprise at oral argument, which is why Brett's very right. If you think the issues are straightforward, both sides have said everything that there is to say because there's a limited universe of record on which the briefs are about. You literally have scoured the earth. There's not like some unknown behind door number 3, because there's no such thing as surprise there. And so in those situations, you have to start getting into the justice's mind and be prepared for every, oral argument, I think, is a different animal than trial, because you can never stop preparing for oral argument because you don't know what the justices are going to ask you. I mean, it might be on some jurisprudence from the 1800s and you're like, well, never read that case. You don't want to be in that situation. But because it can be anything the justices are interested in, but it is on a limited record and you are kind of constrained to the arguments that you raised on the papers, it's an interesting game you have to play.
Yeah, I got lots of stories. I have a couple nightmare stories. The first one, it was the first oral argument I ever had, and I don't know if I've told this story on the podcast or not, but I had made a decision when I wrote the brief that there was a certain case I just didn't think was relevant. I wasn't even going to go into it. I didn't even want to talk about it. So I just ignored it. Didn't talk about it at all. And I was right, by the way. I just want to, for the record, I was right that this was irrelevant. But the problem is, you write your brief, you submit your brief, it might be months before you get an oral argument order. And then it might be more months before you have actual oral argument. So by the time I got to oral argument, I thought I was ready. I, knew my arguments really well. But I hadn't thought about that case since the moment I decided I wasn't going to talk about it. So I get up there, and I kid you not, I didn't even get to say my name. Because normally you stand up and you say, Your Honors, you know,
May it please
such
the
and
court.
such, may it please the court, such and such for the government, you know, and then you start. I didn't even get to that point before the chief judge says, Counselor, I noticed you didn't mention this case in your brief. I would like to know why. And I'm sitting there thinking, I have no idea what case he's talking about, because I haven't thought about this case in like a year, right? So, but in my mind, I'm thinking, well, if I didn't mention it, I must have thought it wasn't relevant. So I say, well, Your Honor, I didn't think it was relevant to the issues. And he says, not only do I think it's relevant, I think it decides the case. And I'm like, oh, God. And so then he proceeds to go on like a rant, like a 5-minute rant about this case and how he can't believe I didn't mention it. And the whole time he's doing it, I'm trying to figure out what the case is about. But as he's ranting, he's dropping little hints about what the case is about. And then eventually it clicks. And I remember what case this is and what it was about. And when he finally takes a breath, I'm able to say, well, Your Honor, that case was about X, Y, and Z. This case is about this. I thought it would be confusing to even bring it in. And so that's why I didn't talk about it. And since this case is not about that, it's not relevant. And he goes, all right, continue. But the thing
Thank
is,
goodness you have like a genius brain, because I'm sure I would have just blacked out.
the funny thing is, the judge I clerked for tells a story about a guy who passed out in an oral argument. And it was this judge who was questioning the guy in a very similar way. And the dude just passed out. And so the whole time I'm standing there, I'm thinking, just don't pass out. Just don't pass out. You know,
Or pass out as a way out.
Yeah, that's a good point. But the thing was, after all that happened, then it's like, I have to now do the argument, right? So like, had to get myself together and then actually do the argument. The other one that happened once is we'd written the brief. We had made this argument that we thought was a good argument. Stand up, at least got my name out. And one of the judges said, if you're going to tell me X, I'm just going to go ahead and tell you, I don't agree with you on that. You're never going to convince me of that. And I'm thinking, well, that was my argument. So I guess I'm going to have to come up with something on the fly here to try. And what's funny about that case, it's the only case that I've lost, which it got summarily reversed by the Supreme Court. So I want to point that out. But that judge dissented. So I was really proud of the fact that the judge who initially said, you will never convince me that you're right, was the only judge who ended up on my side by the time it was over. Anyways, enough war stories.
So what Brett's saying, though, this is why oral argument is so exciting, because, trial is exciting because you never know what witnesses are going to say, and you don't know what the jury's thinking, and you don't know how the interaction of all of these different witnesses who are sequestered from each other will interplay with the jury's mind, and then they deliberate in a black box. Oral argument, we are such law nerds, by the way, that we think all this is exciting in a totally different way. And it's for the reasons that Brett just said, right? You are going up there, and justices specifically, they are, the law of the land of their jurisdiction. So Indiana Supreme Court, all Indiana state courts have to listen to them. And most of them, depends what state you are in. A lot of judges are elected. The U.S. Supreme Court, those justices are appointed for life. And so there's some degree of independence from the politic, right? And so they get to say whatever they want to. And they typically are steeped in these issues. The appellate courts have fewer cases than the trial courts, and their job kind of is to sit and ponder about the law, because their job is to see how this law was going to apply across the board for their jurisdiction, for the jurisdiction that they are supreme over. And they can say things like that. Like, I disagree with you 100%. And you typically will have at least one judge or one justice on your panel who just doesn't like your position no matter what. There's nothing you're going to say that's going to convince them. And your job is not to solely focus on that justice, because remember, it's a panel, and so you just need a majority to win. You need to lovingly engage with that justice and not ignore them, because you have to respect every single judge, no matter who they are. It doesn't matter, anyone who wears a robe, as a lawyer, you're supposed to treat them with the utmost respect. And so it's an interesting social experiment, really, when you have a judge who just is like railing into you, you're going to lose no matter what, you're not going to say anything to convince them, is to throw them enough bones to answer their questions and be respectful, but direct your attention at the ones that you could win and continue with your argument. And so with oral argument, you're going to prepare an outline you probably will not write out what you're going to say because it's an interactive experience. But you're going to have like your arguments that you want to make. You have your cases before you. But other than that, it is kind of an on the fly. You have to have been so steeped in your arguments and the case law that it's in your bones so that when a judge says, what about this case? You can pull it out of nowhere. And you can't say something like, well, you're not supposed to be able to say something like, well, that's in section C of my brief. So section C of my outline. So when I get there, let me answer you, because that justice will shoot back immediately. No, counselor, I want to know the answer right now. I don't care about parts A and B of your outline. I have a question now. You better answer it. And it is just, it's exciting, and it's a lot of intense fire directed at you. And that is kind of where your training comes in as an attorney, is to be able to listen to those questions, pull in the research and the jurisprudence and the facts and record of your case, and mind meld it all at one time as it's coming out of your mouth.
Yeah, I mean, I love it. I mean, I think it's the most awesome thing. I mean, it is nerve-wracking to no end.
I don't think I will never, ever be not nervous before an oral argument.
Yeah. I'm usually incredibly nervous until I get up to the podium. And you're there, the other side's arguing, and you're listening to their arguments, and you're taking notes and trying to think about how you're going to... Because if you go second, what I always like to do, if I go second, is stand up and immediately either agree with something a judge has already said or point out a weakness in the other side's argument. It's always good if you can stand up and say, and I just want to start by saying, Judge such and such, you're 100% right. That's exactly what this case is about, and this is why. And as long as they're not like, well, actually, I don't think that. Like, I was just asking that question, but as a matter of fact, I think that's wrong. And then you're like, oh, well, never mind. But it's really intense, and it's a lot of fun. Just to answer a few questions that people have had in the chat. Yes, when the judges are asking questions, your time is ticking down, and that can be so annoying. When you have a long-winded judge who's meandering all over the place trying to ask a question, and you're not supposed to interrupt, and you're watching your time tick down, and you're thinking, I really need to make some points here, and they just won't get to the point. I mean, that is part of it. And that's a lot of times at the end, if that happens, sometimes the court will be a little bit more lenient with you going over your time if they're sort of recognized that. If they want to hear more things, because it's really for them. I mean, if they need to hear more from you, they will give you more time to talk.
And you'll see this sometimes when a justice has grappled with the briefs and they sit down and they start talking and they kind of lose track of where their question is, and they're not really asking a question because they're basically writing their opinion in their own minds, and then it ends without a question and it's silent. And it's your job to like bring it all together. Like, it's one of those, it's not a fair situation. It doesn't matter. Your job is to serve the justices and to carry your argument forward no matter what. That is a skilled attorney who is able to make the justices feel like they're in a conversation with them, even though it's very awkward. You are standing quite literally at a podium, feet away from the justices who are sitting, in a row in front of you. So it's a very awkward setup, because almost never do you say go to dinner and one person sits on one side of the table and 5 to 9 people sit on the other side, and everyone's eyes are trained on you and the conversation is one way towards you, right? But your job is to make it seem as conversational as possible, because you want the justices to think that your argument makes complete sense. There is nothing that they should disagree with you about without you being pushy or hiding the ball. And that's the other thing that's going to be very important for any attorney at oral argument. Knowing the weaknesses of your case and where you can concede to give yourself credibility without giving away your argument. Because there are certain arguments you cannot concede no matter what, because if you concede it, you lose. But you need to be smart enough to understand, okay, this is a weak point of my argument. So if I give on this part, then the justices are more likely to say, this is a reasonable person. They're helping me craft an opinion that is actually workable and can be implemented for all future cases. So if you don't bend, that is not a good look for you, because the justices will think, well, this argument is an all or nothing. If it's all or nothing, it must be safer to just do the nothing rather than to give them all.
And I think that kind of brings us into what's going to happen in this. If you looked at one thing about oral argument, is the first thing you do when you're going to have oral argument is you read your brief for all the dumb things you said that you wish you hadn't written, because now you're going to have to actually defend them. Because usually, you write your brief, you send it off into the ether, and then 6 months later you get an opinion. You never have to worry about it. When you have oral argument, all of a sudden, the things that you wrote in your brief, you're going to have to explain. on the fly, like why you said that. And do you really believe that? And so I think the way this is going to go and the way it typically goes is each side is going to have weaknesses in their argument. And the justices, if they're good at what they're doing, they're really pushing on those weaknesses, trying to, number one, extend exactly what the argument is and what exactly the rule is you're asking for. So take Richard Allen. You know, you've heard people talk about this online and everywhere else that, you know, Richard Allen has an absolute right to counsel of his choice. Well, that is just not true. It's not true. And the Indiana Supreme Court is not going to say that Richard Allen gets to have who he wants no matter what. Like, they could have stood up and shot a juror in court and it wouldn't matter. They still get to be his lawyers if Richard Allen wants them to be his lawyers. Doesn't matter, right? It can't be that. It has to be some sort of crafted rule. So I think one of the initial things that the justices are going to want from Richard Allen's attorneys and the people who are going to be arguing this are the people who signed the mandamus, who represent Richard Allen for the purpose of the mandamus. It won't be Baldwin and Rosie. Remember, this is not about them. As much as they want to make it about them, they are not before the Indiana Supreme Court asking for relief. Richard Allen is. Richard Allen is asking to have them reappointed as his attorney. So his attorneys, his appellate attorneys will represent him. There'll be an attorney who represents the amicus. There'll be an attorney that represents Judge Gull, and then the probably state solicitor general for Indiana will argue for the attorney general. If I were Judge Gull, I would consider just yielding all my time to the AG and just letting the AG do the argument. But we'll see what happens there. So I think the initial questions for them will be, for Allen's attorneys, why now? Like, why does this need to be decided now? So it's going to be the technicalities of mandamus. Why can't this be decided on appeal? You know, a lot of the cases you cited in your brief were direct appeal cases. They were decided on direct appeal. The cases you're relying on are direct appeal cases. Why do you need to do this at mandamus? Mandamus is an extraordinary remedy, blah, 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 all that stuff, right? And so they're going to have to explain why this should be decided now. And I actually think that's a really difficult bar for them to get over, because I think it's going to be hard for them to show that this is such a unique circumstance that even though in a lot of other states, including in Indiana, typically these kind of questions aren't decided until direct appeal, you nevertheless should do it now. Now, there's some good policy arguments for why let's just take care of it now, but they're policy arguments. And this is the thing. Richard Allen's attorneys are really trying to push the law in a certain way. When the state gets up, they're just going to be citing cases. They're going to be like, you should do what they did. This is the thing. Like, don't change anything. Do it this way. Richard Allen's people are going to be saying more like, look, this is an immediate threat to his constitutional rights. It should be dealt with now. We shouldn't go through the waste of having a trial when we're going to have an appeal and then do this all over again. There's no reason to do that. You've got it in front of you right now. You can make the decision right now. Do it. I think that'll be the first thing. The second thing that I think is going to be difficult for Richard Allen and his attorneys is, what is the relief you are seeking? Are you seeking to have them reinstated? Or are you seeking to have a hearing? Are you saying that their due process or his due process rights were violated because they were removed without a hearing? Or are you saying that under no circumstances could they be removed? I don't think they can say you can never remove an attorney for gross incompetence. I just don't think they can say that. I think that's a loser position. If they take that position, it's a loser. So I think they're really going to have to fall back on, we're really only asking for a hearing. And it'll be interesting to see if that is sort of the position that they end up taking, which is just, all we're asking for here is an opportunity to be heard, which is a much more narrow request for relief than what you've seen in their actual briefs.
Yeah, and that would be an example of knowing the weaknesses of your argument and the concessions you're willing to make, because the hearing issue is procedural. And you can imagine that that type of precedence is something that is not going to move the needle quite as much, because what it's going to just tell lower courts to do is you need to have a hearing on the record before you make this finding in order to remove justices. That is procedural. It's not saying once you have the hearing, you have to meet it has to be a certain standard, or we're defining what gross negligence is, or we're trying to show you what types of witnesses and what type of evidence you need. It's purely procedural, saying have a hearing rather than not have a hearing. You can imagine that that is moving the needle much less and more likely for the justices to agree with you on something that's procedural, but doesn't dictate an outcome to that procedure.
No, I think that's right. And I think the state is going to be faced with a similar thing. Because I think the position the state wants to take is you should just do what the United States Supreme Court said, which is he doesn't have any rights. You can remove him at will. That's the position they kind of want to take. I don't know that that is the smart position to take. I think the smart position to take is probably something akin to what Michigan did when we talked about that one case a couple episodes back, where the Sixth Circuit ended up saying, dude has no rights, you can remove him for any reason whatsoever. When at the state court, the state court had said, we're not going to say he has no right to continuity of counsel. We're not going to say that it doesn't hold any weight. We're leaving open the possibility that that's something that could be important. But in these circumstances, he still loses. I think probably Indiana will want to take kind of that position. Basically, look, the general principle, the general rule is you have no right to choice of counsel if you have an appointed attorney. But reasonable, some courts have said that we're going to take into account the relationship that is built between attorneys once they are appointed and say that there's some value to continuity of counsel. But even assuming that, and this is what you do a lot in oral argument, even assuming you have some right, in this case, under these facts, the court did not abuse their discretion, because remember, this is an abuse of discretion for the trial court, in saying that given all the things that happened, they should be removed. And another thing they'll say is there's no need for a hearing because the record has been sufficiently developed that we know the reasons. A hearing would just be pro forma. It would be pure formalism. You'd go back, have the hearing, and we'd be right back in front of you with the exact same information. This is what they did. Either it was reasonable for a judge to remove them under these circumstances, or it wasn't. And I think that's what the state will get pushed on. And the other thing to remember, Indiana has a constitution. I don't know anything about Indiana Constitution. Nobody really argued about Indiana's constitution in the briefs. It's possible Indiana's constitution provides more rights to the accused than the federal constitution, which state constitutions can do. And in that case, this wouldn't be a Sixth Amendment issue. It would be an Indiana state constitution issue. And the state Supreme Court could say, look, whatever rights he might have under the federal constitution, he's got more rights under the state, and they were violated. So something like that could happen. So I think that's what you can expect to see from both sides and sort of the positions they're going to be grappling with.
Yeah, I think that's exactly right, especially with it's interesting because while state constitutions can provide more rights than the federal constitution, the fact that no one argued about the Indiana Constitution leads me to believe that they're probably pretty similar to the federal constitution rights. But even with that said, I think that's exactly right with respect to the hearing. Because you can imagine, and I've heard a lot of people say this, what's the big deal? Just have the hearing. The big deal here is that it is pro forma, right? Because there is a record developed. We have the transcript of the recording of what happened that led to the gross negligence finding. And we also have a record that has been all submitted, by the way, by former defense counsel of back and forth emails and notice and whatnot, that you can imagine that if this case were sent back just to have a hearing about the facts that we already know, because there's really no further development of facts that anyone is disputing. These are the facts, right? They've been argued in the transcript. They've been in the filings from the defense. It seems like we pretty much know what happened and what the gross negligence finding is based on. What that would just do is to delay Richard Allen's trial even further. And obviously in the papers, Richard Allen's former defense counsel are saying, set trial within 70 days. He needs to have speedy trial rights. Well, guess what? He's not going to have any speedy trial if the Supreme Court decides they have to have this hearing, because what's going to happen is it gets sent back to Judge Gull. They have a hearing, hash out the exact same things we already know happened, except on the record, except that probably won't happen tomorrow because it's about to be the holidays. The Supreme Court first has to write an opinion. That takes some amount of time, usually months in a regular case, maybe weeks, maybe even days in this case. Let's say they really want to move quickly, but it takes time to write an opinion, issue the opinion. Then the court below, Judge Gull, has to find room on her calendar to have the hearing, especially among the holidays. They have the hearing. Then guess what's going to happen? They're going to find gross negligence. The exact same thing of what has happened will happen again. They will be removed, and then they will appeal again. Maybe another mandamus, maybe another appeal. And so we're going through the exact same motions. And typically, our courts in the United States are not just meant to be on technicalities and checking boxes. It's really the spirit of the law. And in this case, if I were the argument, I would argue vigorously that there is no need for a waste of time hearing. Perhaps that would have been best practices. And in another case where the facts were not so well developed in terms of why the judge did what she did, yes, maybe in that instance, Supreme Court, you could send a case back for a hearing, but this case is not the one in which you do it. And so don't move the needle on the law because the facts are not in favor here. And this is, by the way, why we always say bad facts make bad law, because you can imagine that if the judge said nothing, we have no record of why she removed them. There had never been a leak of photos. There had never been accidental emails to people outside of the defense team with evidence. None of that happened. Everything seemed to be going swimmingly, and one day the judge just said, I'm going to report you to the bar or you can withdraw. And literally nobody understands why. You can imagine those are pretty bad facts, right? And you can imagine in that case, if that were the set of facts before the justices in a mandamus, they may be more willing to say, no, we need to send this back for a hearing. The case before us is not that case. And that's what I would argue if I were the state.
And you never know what Supreme Courts are going to do. It is really difficult to imagine a path that works out well for Alan. As Alice pointed out, there's some incongruity in pursuing this while asking for a speedy trial, because the argument's going to happen on January 18th. Maybe they will get it out quickly. Maybe they'll already have an opinion drafted. In simple cases, when I worked for a judge, I can remember a case where we had oral argument. We came out of it. The judge told me what they were doing. I wrote the opinion. We issued it the next day, right? That was a simple case. That was a very straightforward case. This, I have a feeling, given the impact it's going to have down the line on the rights of indigent defendants and attorneys, and the fact that, will this be unanimous? I mean, maybe it will be. I kind of feel like the only way this moves quickly is if it's a quick denial. A quick denial could move very quickly because basically in one page, the court could say, look, this is not appropriate for mandamus. Mandamus petition denied. It's pretty short, right? I mean, you just explain, you'll be able to appeal this later. If it's a substantive opinion, then that's going to take a while to write, the majority opinion. There may be concurrences. There may be dissents. Imagine a world in which it took 6 months for this opinion to come out. I mean, imagine at the end of 6 months, the Supreme Court grants the opinion, reinstates Rosie and Baldwin, and gives them the 70 days speedy trial. The trial would be right around October, which is where it's currently scheduled to be. So, the weird thing that's going to be going on, as we've said before, this is not a direct appeal. So a direct appeal stays the lower court. So while you're appealing something on direct appeal and interlocutory appeal, what's going on in the lower court is stayed. It stops. This is a mandamus petition. The lower court's rolling along. If this takes 6 months to be decided, presumably, unless a stay order gets entered in sort of interest of justice, conserving resources, let's go ahead and stay the lower court case, which is going to push that trial date back, then presumably his current attorneys are going to be working on this case. And it's such a bizarre world we're in with this case, where you've got former attorneys fighting tooth and nail to get back on the case while current attorneys are working on the defense, moving towards a trial date. I don't know what's going to happen. I honestly take sort of the opposite position. I think a lot of people thought, oh, they're having an oral argument, that's good for the defense. And I totally understand why that is, because normally that's the case. I feel like if they were going to win, they were just going to win on the papers. Like the court was just going to say, this is so obviously flawed. This was so obviously without process. This was so messed up. You've got to go back and do this again. And since they didn't do that, it's really hard for me to work out how they win after an oral argument.
Yeah, I think that's right. I wonder if they're grappling. The Supreme Court is grappling with like the rights of Richard Allen and how they're lost. It could very well be. This has happened to me before, where oral argument is granted to basically rail out the attorneys for the position they've taken. I don't necessarily think that's going to happen here. It has happened to me before. Thankfully, it wasn't me who was the side that was being railed out on. It was the other side who had filed the brief, and I just had to nod along and say, yes, Your Honor. Again, oral argument is a black box, why they've granted it here, except that these are interesting issues. It is not utterly clean, right? It would have been more clean if there had been a hearing and there had been a transcript in the first instance before, and a finding of gross negligence before the removal. But here, I think the best they can argue for truly without egg on their face is to argue to have a hearing, which, if I'm the justices, I'll just shoot back with the argument I've already raised, which is, but you want speedy trial for your client. We already know all the arguments here. How does that serve the interest of justice for Richard Allen? So argument will be in a month. We will absolutely listen to it. Only 60 minutes long. Now that we know, not 2 hours or 3 hours. And we'll come back and we'll, see what is said. Now, one thing that is atypical at oral argument, typically the justices do not rule from the bench. And the reason is it's not just one judge who gets to decide what the opinion is. If you're at the trial court, oftentimes in motions, maybe ones that are not too substantive, the judge will rule from the bench and say, okay, I've heard argument, counsel, your motion is denied. From the bench, they don't write anything. Not at the Supreme Court, because it takes a majority in order to win on your side. And one judge doesn't get to speak for everybody except on the papers. Because what happens after the oral argument is the case is typically taken under submission. So the chief judge will bang the gavel and say, thank you, counsel. This case is taken under submission, and then they file out. They don't talk to the litigants. They go back, and typically those justices all go into a conference room and they do what we call conference. They usually take an initial vote. Usually it's just the justices in there, no clerks, no other staff. And they say, where's everyone leaning? No one's bound to it, but they'll say, would you grant however many hands? Would you, deny this? However many hands? And you begin to see likely how the votes will shake out. And the chief judge isn't necessarily going to be the one who writes the opinion. It's usually going to be someone who voted on the side that's likely going to prevail. And the chief judge gets to assign who's going to write the opinion. And then the writing campaign starts, right? Let's say it's 5-0. There's no one who really disagrees. You're not bound to that. Then they'll appoint someone to write the opinion. That judge will write the opinion and then circulate it to the other colleagues, the other justices, because they all have to sign off on it. And typically there's a lot of back and forth. This is why it takes a lot of time to come out with a substantive opinion, more than just a grant or a deny, because one person may not be reasoning the same way another justice is. And you want to get as much agreement among the justices as possible, because that's a greater, it's cohesion. You're all reading the law. You don't want to be split on reasoning because it creates confusion in implementation for the lower courts. So that's procedurally what happens after oral argument. It's really just begun for the justices. And then once they settle on an opinion, there's the majority opinion where it's the majority, but then any justice can write a concurrence or a dissent. And obviously a dissent is what it sounds like. You don't agree with it. You don't have to write an opinion, but oftentimes if it's an important enough issue for that justice, they will write an opinion explaining why they think the majority got it wrong and why their opinion should prevail. And then also, even if you voted with the majority opinion, you can write something called a concurrence, because maybe there's a line of reasoning that the whole majority didn't really agree with, but you think that that's important enough to write about, because there's different ways to agree with the majority. You can simply vote for the outcome, but disagree with all of the reasoning, or agree with parts of the reasoning, or, there's so many ways of writing these opinions and ways to vote that's not as simple as thumbs up, thumbs down.
Yeah. And look, we'll all be trying to figure out what they're going to do. We'll all be listening to the questions and trying to decide based on that. That can be a fool's errand. There are plenty of times where people walk out of an argument thinking it's going to go one way and it goes the other way. Though I'll say a lot of times there's at least one or two judges who very clearly are showing their cards from the very beginning. But And the other possibility, and I hope this isn't what happens, is a cold bench. Alice mentioned ordinarily they start asking questions immediately. One time had an oral argument, and so the day before I did my argument for my wife, and I was like, so, ask me questions, like, the general thing. So ask me questions, I'll argue. So I do my whole argument, and she never asked me a single question. And so then I got finished, and I was like, why didn't you ask any questions? And she's like, well, you never know. They might not ask any questions. And I was like, they're going to ask questions. Next day, I had the argument. They didn't ask me a single question. And I was like, well, I guess she was prescient. So that's possible. Right. But let's hope that doesn't happen, because
you don't want that to happen.
Yeah,
you know why? This is the reason you don't want it to happen. First of all, you want it to be interactive because it means the justices have engaged in the legal issues. They've read the papers. They've read both sides of the briefs. They've done their own legal research, and they've thought about the implications of your side. And you want them to do that because the more engaged they are, the more you're able to convince them of your side. Because if someone has no idea what you're talking about, it's hard to engage them and be like, no, this is why I'm right. And they're like, I have no idea what you're talking about. So you actually want a hot bench. And the other reason we don't want a cold bench in this particular case is why, right? Like it's you would think that they have set argument because they have questions. Otherwise, time is of the essence. Time is clicking. This is a circus that they can get rid of with a stroke of a pen if they just want to deny the mandamus, or something very serious is happening and Sixth Amendment rights are being violated and they can fix it this second, and they should. And so the reason I think that there's oral argument is it's not either of those. Right. And so there's some reason for wanting discussion. And that's why I would be surprised if they had no questions.
Yeah, I would too. I think they'll definitely have questions. And I think it'll be interesting to see what happens. And if this really is about Richard Allen, or if it's more about, hey, this is a rare opportunity to actually establish what the law is going to be in Indiana about attorneys. Because these cases are rare. If you read either of the briefs, we did a legal briefs on this, cited a bunch of cases. Pretty much every case we cited was in the state's brief, because there aren't that many more than that, and the Richard Allen, they were pulling 1960s cases from California. So this is an area of the law which has been litigated pretty fairly well in federal court. Federal court's very clear about what your rights are when it comes to your attorney and having one appointed. But in the states, it's still kind of an up-in-the-air question, and that's the one advantage Richard Allen has, is this is a state court. And state courts, obviously, can have different rules. That's the beauty of our constitutional republic, 50 laboratories of democracy. So I guess we'll see what happens.
That's right. Well, Brett, before we sign off for the day, this is all reading tea leaves. We'll have a lot more to talk about substantively in about a month on January 18th when the case goes to oral argument. Before we sign off, do you have anything else you'd like to say?
Just glad I made it.
I'm glad you made it too, Brett. If you have any questions, we are happy to answer them. You can reach us at prosecutorspod@gmail.com. You can also find us on the social medias, Facebook, Twitter, X, Instagram. We are at prosecutorspod. And also, there's great discussions about these issues and more on our fan-run Facebook group, The Gallery. Some really great questions that come up there, and great fodder for legal briefs topics. So we love hearing from you guys. If you think we got anything wrong, let us know. We also like to make sure that we correct ourselves. So until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Oh, you made it. You okay?
Yeah, I'm fine.
I'm sorry. That's just terrible. Well, my kids fell asleep while we were recording, so that's good.
That's good. Yeah.
I'd like to let you know, Brett told me today, and then I'll let you go. Today's a big day. I have been recording on diaper boxes. Like, my laptop and my microphone have been on two different diaper boxes for, like, I don't know, how old is Brittany? Like almost a year old. And today I texted Brett and I was like, I am going to not be on diaper boxes today. So